Welcome to JMW's Inside Man YouTube channel. Tom Bayliss is my guest. Tom is an associate solicitor within JMW's property litigation team. So, Tom, I've heard an awful lot in the news recently about RACC, so that's RACC. What exactly is it and what's happened?
So RACC stands for Reinforced Autoclave Aerated Concrete. It's a lightweight, cheaper alternative to your conventional concrete and was primarily used in construction between the 1950s and the 1990s. As the name implies, it's aerated, meaning that there's little pockets of air within the concrete, and it can be vulnerable to structural failure where the concrete itself is exposed to moisture. So within this concrete, there tends to be metal beams through there, running through the concrete, and it's where the material is exposed to moisture. It can soak that moisture up, then it leaves the metal supporting beams vulnerable to corrosion and rust, thereby over time weakening them. And RACC tends to have a lifespan of around 30 years, meaning obviously with the periods that it was primarily used in construction, we're coming to the end of that lifespan now, hence why you're seeing it so much in the news with regards to, you know, your public schools.
And you mentioned a lot of worrying words there, really. What does it mean for landlords, Tom?
So I can see, as you've seen it a lot in the news at the moment, but I can see RACC being quite a big area of litigation over the next few years, and definitely within the landlord and tenant sphere. I mean, we could talk all day about all the different areas it could crop up, but in one particular area, I think it could be particularly problematic is within the context of dilapidations disputes. So, as many will know, dilapidations refers to items of disrepair covered by the repairing and decorating covenants within a lease. So it covers breaches of a tenant's covenants relating to the physical state of the property at the end of the lease. And ordinarily what will happen is towards the end of a lease, a landlord will instruct a surveyor who will attend the property and prepare what we call the schedule of dilapidations, which is essentially a schedule setting out all of the repair works that would be needed to bring the property back into the standard of condition that is required by the lease if, for example, the tenant had complied with their repairing and decorating covenants. And that schedule will set out what those works are and give a cost estimate for those particular works, and other losses may also be recorded within that schedule as well. So classically things like loss of rent. So there's going to be a period where the landlord's having to carry these works out. They're not going to be able to relet the property. So there's going to be a period where it's a loss of rent, maybe exposure to business rates liability because there's not a third party in there anymore. So the landlord becomes liable for those losses as well. So I can see RACC being problematic in relation to the landlord's ability to pursue a tenant for damages within a dilapidations claim. So one argument that is often raised by a tenant in the context of these sorts of claims is something that we know as supersession, which is the second limb within Section 18(1) of the Landlord and Tenant Act 1927. Now, supersession is essentially the principle that a tenant should not be liable for damages for works where a landlord's proposal would then, or intention for the property would then render those works redundant. So, for example, if we had a property whereby there was an internal wall, a tenant was obligated to keep that property or that wall in a good state of repair and have to decorate it maybe every few years or so. If they didn't do that towards the end of the lease, and in fact it was the landlord's intention shortly after or at the end of the lease term to demolish that internal wall, for example, because they wanted to make the property more open plan, then the argument for the tenant would be, well, I shouldn't be responsible for those works because they're going to be rendered redundant. Now, the burden of proving supersession it's on the tenant, but bringing it back to RACC, what I can foresee happening is where you have a property that was constructed in the 50s and 90s and is primarily constructed out of or has elements of RACC, you could have arguments whereby the tenant will say the landlord will have to carry out significant structural works to the building because of this vulnerable concrete. So the tenant could say, well, I'm not responsible for those works because they're going to be rendered redundant because you have to demolish part or substantially a lot of the property. And that could knock out a substantial part of a landlord's claim. And the tenant could also argue potentially that it's going to take a significant amount of time to do those works. So for that period, because they're responsible for doing those works, the landlord, they're not going to be able to relet it to a third party. So a tenant could say, well, I'm not responsible for that loss of rent because you had to carry these works out. You wouldn't have been able to relet the property in any event.
So, Tom, how can you and the property litigation team here at JMW Solicitors help?
Okay, so immediately thinking within the context of dilapse claims again, one thing that landlords may want to start considering is not only instructing their dilapidations surveyor to attend a property to prepare their schedule of dilapidations. At the very outset, they may want to also instruct maybe some sort of structural engineer to attend the property with a surveyor. So that engineer should hopefully be able to determine whether or not any part of the property comprises RACC. And they'll also be able to advise on whether or not it will be necessary for the landlord to carry out any repair works to those areas of the property. So at the very outset, the landlord is given a good indication as to whether any part of their claim could potentially be reduced by virtue of the fact that they're going to have to do these works later down the line. Thinking about leases generally, where we have landlords where their premises or properties in their portfolio were constructed within the 50s and 90s, and there's a fear that the property could comprise RACC, then what they may want to start doing is revisiting their precedent leases to see how those elements of the building are dealt with within that lease. Is it the tenant's responsibility? Is it the landlord's responsibility to repair? So that might be something a landlord wants to do, revisiting the leases to see whether that needs redrafting or tweaking, see if they can push some of that liability over to the tenant. And on the flip side, if you're a tenant or you're acting on behalf of a tenant, you may want to revisit those leases where you've got a 50s and 90s properties and see whether that liability is on the tenant and if you can push it back to the landlord. So it very much depends sort of what side of the fence you're sitting on, really.
Tom, thank you very much. And if you'd like to contact Tom and the property litigation team here at JMW Solicitors, you can email insideman@jmw.co.uk or call 0161 82 81 999. Please also subscribe to the JMW Inside Man YouTube channel for the latest legal news, hints and tips. I'm Dominic Walker, JMW's Inside Man.